Today, we are going to be focusing on double counting and double compensation as it relates to DER enablement. But let me kick it off with a little bit of background for anybody that's new.
Hey,
Hi,
Suzanne Bertin here, and I am working on the policy tracker related to FERC Order 2222.
and I'm David Kathan, and I serve as the advisory board chair for Collaborative Utility Solutions. And I have worked at FERC in the past and was the lead on Order 2222 and provide that perspective and will be the person who'll be talking specific about double counting and double compensation webinar.
So just FYI, we always have to do the disclaimer that the DOE has sponsored this initiative and allowed us to set up the website and everything. But any views expressed are ours and ours alone, and they're not liable for anything that I say. Overall, the structure of our project with DOE is to provide bi-monthly reports, and in the alternating months, a webinar covering what we released in the report. The FERC2222.org website was initiated earlier this year. It does have all of the tracking information that we are collecting for each of the state's jurisdictions or different proceedings that may be happening in relation to DERs and DER enablement around the country. We are producing white papers in addition to these reports and have enabled a function for discussion groups on the website. We are curating a library on the FERC2222.org website. We are not trying to make it an all-encompassing every paper that's ever been released about DERs. We are trying to curate that to some of the primary papers and a shorter set of information that provides a more effective kind of short list library for people if they're interested in looking. The bi-monthly reports are based on what is current in industry. As you will kind of go back and see all the reports that we have posted. We've posted data, security, privacy, consumer protections, different thought processes on each one of these as we've been interacting with the different groups around industry. And we take an analysis piece of that as well as providing updates on the tracker for what is happening. And just a quick reminder that we do have the chat rooms live. I've been told that people are having conversations in there. We do not monitor, record, or otherwise allow access to anybody outside of the regulatory community in these chat sessions. So you have to have a registered email with a recognized RERA to gain access to these chat rooms. But again, we do not monitor, and the behavior is yours to make sure that it's moderated. We can intervene if we get a note from anybody that says something is inappropriate, and we'll remove the content and the person from the chat sessions in that event. But I encourage you to join in the chat room sessions if you've got additional questions of other regulators or staff. And that is a forum for people to have these discussions around any of these topics. The chat rooms are set up. There's a general one, but there are specific topic areas for the top issues list that has been identified. Things like interconnection, metering, double counting, the different pieces of this. The chat rooms are set up around specific topics to make sure that it doesn't become unmanageable. We did break it out into the key issues list. So I will turn it over to Suzanne to give the update on the current events.
All right. Thanks a lot, Chris. So as Chris mentioned, these webinars follow the reports that we do in alternating months. And so the updates that we have here were reflected in the May report that we published. So first of all, FERC did approve PJM's third compliance filing, and there were two issues that were addressed in that filing. First one had to do with meter settlement timing, and specifically that was that PJM is requiring DER aggregators to follow the current one-day meter submission deadline. And then the other issue is a shift of the implementation date from February 2nd, 2026 to February 1st, 2028. Meanwhile, in April, the MISO DER Task Force and Organization of MISO States met again to continue their discussions around FERC Order 2222 coordination to review findings and make plans to continue working on coordinating on that and implementation. Maryland, of course, has been very busy. They issued Order 91603 regarding the implementation of FERC Order 2222. And to that end, they had several decisions there. They largely had directed the state's utilities to file some conceptual reports within 6 months on how they can implement some of the key issues around 2222. And so they, in addition to that, they did make several findings. First of all, that they were in support of a broader scope for the implementation of VPP regulations and the harmonization of retail and wholesale VPPs in a single docket. They directed Maryland utilities to start information technology systems to implement VPPs. And they also referred a number of the 2222 implementation issues, such as interconnection, dispute resolution, and double counting into their ongoing interconnection work group activities. And then in addition to that, continuing their implementation of the DRIVE Act, the Maryland PSC also issued an order that dealt with the DERA registration application. And so the commission staff did make some additional recommendations regarding the proposed application, and the commission approved that proposed license to operate application, and that approved application will be effective July 1st, 2025. Additionally, the Iowa Commission opened a proceeding to request input from stakeholders on whether the commission should lift its prohibition on aggregators of retail customers, or ARCs, being able to bid into wholesale markets. And in that proceeding, the commission was also seeking input on what its role should be in facilitating implementation of FERC Order 2222. Comments on that were due in April, and the commission may schedule one or more workshops after reviewing those comments. Next up was New York. They issued their Grid of the Future initial plan. Stakeholders were invited to file comments on the plan by May 21st, but that deadline has been extended to July 15th. Additionally, in the Commonwealth of Virginia, the State Corporation Commission requested comments on proposed interconnection rules for small electric generators and storage. Those comments were due just a few weeks ago on June 9th. And then also in May, Virginia Governor Glenn Youngkin did sign into law the Community Energy Act, which requires Dominion to petition for approval of pilot programs, including virtual power plants, by December 1st, 2025. And with that, I will turn it over to Dave for discussion of the topic of the day, which is double counting.
Hi, thank you. And thank you for Emily for putting the next slide up. So what I'm going to be talking about for the next several slides is a major issue that's associated with order number 2222. And that is, given that DERs are on the distribution system in the retail sector, and there will be aggregated to participate in the wholesale market, there is a potential for double counting these resources. So FERC, developed some core principles and rules associated with how double counting and double compensation can be addressed and ensure that does not happen. Bottom line, the policies to limit double counting are crucial to preserve the integrity and system operations and market efficiency. In particular, double counting of DERs can lead to an overestimation of available grid resources, which can undermine the accuracy of system operator dispatch, reserve planning, and contingency responses. FERC, in its notice of proposed rulemaking, first proposed a broader ban on double counting, but based on comments, it narrowed the ban. In its final rule, FERC set requirements to remove the potential for double counting resources, which basically are claiming the same DER capacity simultaneously for multiple services, or compensating resources for providing service. In specific, FERC Order 2222 requires each RTO and ISO to revise its tariff to allow DERs that participate in one or more retail DERs to provide multiple wholesale services and include any appropriate restrictions on DERs participation in RTO ISO markets through DER aggregations, if narrowly designed to avoid counting more than once the service is provided by DERs in these markets. With regards to restrictions, FERC was specific, and it said that it's appropriate for RTOs and ISOs to place restrictions on DERs that want to participate in aggregations after determining whether a DER proposing to participate in an aggregation is registered to provide the same service and either individually or part of another RTO ISO participant, or two, it's included in a retail program to reduce a utilities or other load serving entities obligations to purchase services from the RTO ISO market. A good example would be counted as a double counting would be if a utility in an organized market was using a DER aggregation or VPP to lower its peak load contribution that it's required to meet in the capacity markets, like for example in PJM, but at the same time they want to bid that same capacity into the capacity market. That would clearly be a double counting or double compensation, and that would not be allowed. Note that 2222 does allow state and regulators to condition the participation of DERs in RTO ISO aggregations if it's already participating in other retail programs. However, it's important to recognize the value that DERs can serve at local distribution level in addition to the value at wholesale or RTO ISO level, and develop the appropriate rules to allow these resources to be utilized and support the entire grid. As far as RTO and ISO compliance, all the compliances are in. Actually, several of the RTOs already have completed all of their compliance obligations. Several are still outstanding, but the bottom line is that they're coming down to just technical issues at this point. On the double counting and compensation issue, they've all compiled with this direction. Most compiled by requiring double counting to be addressed during the capability assessment period. So the electric distribution companies, EDCs, are required to review the capability and the reliability impact of a potential DER in an aggregation within 60 days. So required to look at double counting during the capability portion of that, and also do that through attestations or through various other rules. Some of RTOs have chosen to use metering as a basis for that, but pretty much the issue is during the EDC review and through attestations, they will addressing the double counting issue. A key issue going forward, and this is going to be important during the implementation at the state level, is the role of the regulator, and RERA as what FERC calls retail electric regulatory authorities. RERAs will need to develop contemporary rules, complementary rules to our RTR ISO rules that govern the ability of DERs to participate in retail tariffs programs and wholesale markets I indicated just previously. And the regulators should proactively collaborate with utilities, DERs, and aggregators to create or modify rules and tariffs to establish guidelines governing this dual participation with consideration of both normal and emergency operation at the bulk distribution system levels, so long as these rules do not conflict with FERC Order. And local regulators should be consider is issues having to do with metering, sub-metering, measurement, and data sharing rules. As regulators review their state policies and rate structures, they should allow DER participation if they are able to use in their own state. So there are several key issues associated with that states need to be looking at and local regulators. The first is net energy metering. This is a key issue, especially to determine whether DER will be able to provide ancillary services or capacity to wholesale markets, in addition to being compensated for selling energy to EDCs. There were a number of comments on this in the record on Order 2222. But there are several good examples of how some states are addressing this issue. A good example is guidance that was provided by the Massachusetts whether solar plus storage could participate in their forward capacity. They determined that the provision of capacity from solar plus storage was a separate service. So therefore, the aggregator, the VPP in that region could then separately bid that capacity, that capability to reduce consumption or operate their storage during peak periods, and able to participate and clear in those markets. Alternatively, another example is the Pennsylvania PUC took a different tack and found that energy metering was provided a full retail value, and it's a full bundled retail rate, which includes generation, transmission capacity, ancillary services, and distribution components. So therefore, they felt that there was no ability to separate, and there would be double compensation and double counting if net energy metering net energy metered DERs were participating. So bottom line, it depends on RTO, ISO rules, and also state rules. The state regulators and local regulators will need to make clear delineations on the participation of net energy meter DERs. State regulators will also need to determine whether they will limit condition participation of a DER in a DER aggregation based on its existing or potential participation in a retail program. And then there needs to be and look at the difference between providing distribution grid service and provide particular care will need to be focused on clearly delineating the difference between the provision of these services. This is an issue I know that Maryland is examining because the DRIVE Act requires the development of VPPs who are to provide distribution grid services. But at the same time, Maryland is trying to figure out how to allow for VPPs and DER aggregation to participate in wholesale markets. So this is an important issue that needs to be resolved and thought through. So with that, I'm going to turn it back to Chris, who will take us home.
Great. Thanks, Dave. You're going to have to yell at your fiber provider. You're a little broken there. So overall, the fundamental piece of creating a thought process to enable DERs within the framework of our industry, there is a tremendous amount of work going on at various different places around the world. We supported efforts in Australia to assess DER impacts and the thought process and creation of the first registry there to support the enablement of DERs, and ultimately having that single point of truth where all stakeholders involved in the transaction, whether that is the customer, DER owner, aggregators, electric distribution companies, TSOs, RTO, ISOs, regulators, or other critical stakeholders from software vendors or program implementation groups, having access to the data in a secure fashion is a key outcome that we identified in our work in Australia, Germany, and Ireland, where they have very significant penetrations, and moving forward into the efforts that DOE has been working on throughout the United States. The overall thought process of dual registration, double counting, we do always try to point out that there is a significant amount of capability that is enabled by DERs into the distribution grid, and the opportunity for both a utility retail program and an ISO market product do coexist as long as the framework of the regulation is thought out in advance and each specific RERA deals with that opportunity as they feel it is appropriate within their state. Net metering, as Dave pointed out, is probably one of the bigger issues, as most of the states, in the views that we have collected from our conversations with everyone, views net metering as a full value concept covering all aspects of capacity, energy, ancillary services, as well as infrastructure and metering cost of service, and therefore will likely, in most jurisdictions, not be allowed. The consumer would need to be on a different type of tariff to participate in other programs outside of net metering, whether that is a distinct utility program or whether that is RTO ISO market product. And fundamentally within the framework of what the industry is looking toward, this registry concept provides that single point of truth that allows knowledge and information about whether or not a specific DER or DER site is participating in any form of aggregation and what the status of its current EDC tariff is, and whether or not it is eligible to be aggregated on a go-forward basis. Throughout the last several months and within the last report, we did start touching on consumer protections. The overall thought process of consumer protections, as many of you are undoubtedly aware, some of the recent rulings for bad faith behavior in the aggregation of customers in this process really points to the need for the thought process around a structure, a registry, a software system of some form or fashion that would allow these consumer protections to be embedded to ensure that a consumer does have to proactively select an aggregator that is documented through that system and doesn't allow that customer site to be aggregated without that validation from the consumer within the framework of that system to allow their site to be aggregated. Within the structure of a electronic system, a registry, the ability to have the statewide data privacy policy as exists in a few places, or the specific privacy policy approved by the EDC and their RERA can be a part of that process in selection of an aggregator that the consumer understands that once they select that aggregator, that their data is now subject to a more open capability for their aggregator to participate in a utility program or an ISO market product. And they have the ability to make sure that they understand that prior to selecting their aggregator and having their aggregator be able to move them into a program. Obviously, switching will need to be enabled through this type of system to make sure that multiple aggregators aren't claiming a single DER site, and making sure that that capability does not exist in the marketplace to send a false signal to a utility or an RTO ISO about the capacity that's being aggregated and delivered to the grid or market programs. And ultimately, within the framework of a technical system, there needs to be information sharing with the DER owner. While the vast majority of consumers don't track this very closely, they do need a place in which they can go log back in and see who their current aggregator is, what either retail programs or market products that they are currently enrolled in, what the timeline of that participation is, and if they are in the system proactively attempting to change their aggregator, they need to be provided the appropriate information that says, yes, you can switch, but you're currently part of this aggregation. That aggregation is participating in a program that's over on August 31st, and they can switch at that time. But the obligations of the aggregation that have been registered are through August 31st, and they can't switch until that time. All of these things on the consumer protection side need to be enabled as we move towards a multi-million persona kind of thought process around DERs, and ultimately pushing paper or moving spreadsheets on email are not going to be an effective way to make sure that we protect the consumer and make sure that no bad faith decisions are made through this process. And then ultimately, within the framework of the electronic systems, we'll make sure that the DER cannot be included if it's on, in a state that has net metering, and that state and that their RERA has determined that net metering is not possible. When the consumer is attempting to select an aggregator, it will inform them proactively that they're currently on a rate that is not allowed to participate in additional programs. And if they desire to participate in a program, they will need to work with their utility and their aggregator to change the tariff that they're currently enrolled with to be able to validate and have a valid site into a registered aggregation. And finally, Suzanne and I would like to ask for all of your help. We do pay attention to all of the dockets. We participate in different ISO working groups, task forces around what is happening across the country, but would appreciate any input or feedback that anybody has about current events that are occurring in your state, in your jurisdiction, your ISO, your utility, in terms of making sure that we can get that into the tracker and share that information broadly within the tracker to anybody that would like to keep track of what is happening on a broader scale basis. So that concludes kind of the formal side of what we were presenting today. It's a little bit shorter today with this single topic. And we knew that lots of people would be gone for starting into the vacation stage. So we'll open it up for questions. And Emily, I'll let you MC.
All right. Looks like Thomas Chamberlain has a question. Thomas, I allowed you to unmute yourself if you would like to do so.
Thanks, Emily. This is Tom Chamberlain, Energy. Can you hear me okay?
Yes, sir.
So two quick things. On your last slide, just making you aware in Texas, they've raised a docket 54233 on DER interconnection requirements above and below 250 kW. That's out for comments right now, so that might be one you want to start tracking. Also, I believe Arkansas is going to be looking at DER dockets here in the near future, probably sometime later this year or next year, just as an FYI. My actual question is, you guys talk a lot about DER registries, I know on the call and in the past. Where do you think it makes the most sense to lodge or host that DER registry? Is it nationally, a national registry? Is it at the RTO, at the state, or at the utility, the EDC? Thanks.
Thanks, Tom. Thanks so much for the update. I'm sure Suzanne was furiously taking notes. They're very embroiled in Texas, so I know she knows about that one. But that's great news on the Arkansas piece. I hadn't personally heard about that one yet. Regarding the registry, we have been working across many different jurisdictions to basically ask the exact question that you have asked. And the thought processes that everybody has when they answer that question are largely based upon what they do. Like if you sit in an ISO, you're going to say, I need an ISO system that does these things. And your thought process around what you would implement as an ISO makes absolute perfect sense and would make absolute perfect sense if there weren't other affected parties. Emily, is it possible for me to share my screen within
Yeah,
this type of a?
you can certainly try. Let me stop sharing this and then, oh yeah, we can see your screen now. Well, at least I
Okay.
can.
So just we are participating in a process within the framework of the NASB working group around standards for a registry in collaboration with FERC and NERC and DOE at NASB. And the point of the thought process, and this is actually a presentation we're giving today, it really depends on where you sit in the overall structure of the world. Having been a utility person for many, many years, we don't like things not invented here or invented for our specific need as a utility. So ultimately, as you have different personas around, people are going to have a different view of where that needs to sit. For our country currently, where we have an estimation that we're 100 to 200 gigawatts short of our needed capacity on the grid in the next 10 years, DERs need to become a functional part of what's going on. So if you step away from what your role is and use a reference of what occurred through the renewable energy credit tracking systems, we started out with about 60 or 80 different systems. There were utility form systems, ISO form system, independent systems, regulatory required systems. That has pared down to about 11 systems today, but many of these systems, I'll use the Missouri example where they have 2 ISOs and a whole section of the state that isn't represented by an ISO. And they have multiple rec tracking systems that don't, they are unable to trade across the boundaries of those areas. And so ultimately, our view of this and our recommendation of this is a much broader scale implementation, mainly due to the fact that this data needs to be used by EDC planning groups, ISO RTO planning groups. Eventually will need to be settled. It needs to be available for people to do the capability and reliability review, which means that the operational aspects of the data need to be there. The consumer needs a voice in making sure that there isn't any bad faith behavior in the sense of selecting their aggregators. And ultimately, there's a tremendous amount of reporting that is already required and will be continuing to be required in this. And each one of these personalities, from the customer, DSO, TSO, RTO, regulator, equipment manufacturers, all of these groups represented here have a stake in this, and independent systems being created by all the different groups is fundamentally going to lead to a thought process that says, if we have 3,000 utilities, 9 ISO RTO groups, all the different state regulators, which, great, we have 54 state and district regulators, but from an approved RERA perspective, you have city councils for munis, you have boards for co-ops, a couple thousand co-ops. So we're looking at thousands of different groups. And if each individual group produces their own system, and basically, let's say it's $1 million to build a system, let's say it's $250,000 to develop an interface, which is the basis of these numbers, we start getting into a position in our country where we're spending billions of dollars on the administrative software piece. So we are promoting collaboration and cooperation, at least at a state level, for a common thought process around a registry by a state at a bare minimum. And being able to move that to a broader scale for potentially an entire ISO or a national footprint would obviously drive those costs even lower. All right, that was a very long answer, Tom, but since we're right in the middle of this and presenting on exactly that today and trying to answer those questions, I wanted to go a little bit more detail.
No, thanks, Chris. Appreciate your answer.
All right, does anyone else have any questions? All right, Zach, I'll go ahead and unmute you. All right, you should be able to unmute yourself now.
Great, thank you, and thanks for the presentation. I have a question. I'm not sure if you can answer it, but my question was about the back in the dual participation and double counting. You highlighted kind of the different interpretations of Massachusetts versus Pennsylvania with regards to net energy metering and compensation for capacity for solar and battery or solar and storage systems. And I guess I'm just wondering if anyone can share a little bit more detail about the different rationale that was used between those two decisions, and also or is there like a general best practice that anybody would want to assert between those two decisions? And I guess I'm wondering, just for context, so I'm in Indiana, where the prevailing retail DG tariff right now is not net metering. So anybody who's adding solar and storage today would be getting basically wholesale compensation. So I don't really think it's an issue for them. They're definitely not getting full retail compensation. But for the 10,000-ish current net metering customers in the state, we're trying to figure out what impact it might have on them. And I know the Indiana regulators are kind of weighing that question right now. So just kind of curious to dig into that if anybody is able to.
I'll take a crack.
Oh, okay, good. I was going to say, David, if you want to start, and then I'll add in.
I'm not turning on my video because of my, that bandwidth potentially is a problem. But and tell me if it's not working. Also here, I need to talk to Verizon sometime today. So it's a big issue, and and I think it's a more fundamental, what is the interpretation of the service being provided by net energy metering? And I think there's a spectrum that one could look at it. One is indicated was the Pennsylvania approach, that it's a full requirement that is being provided to the customer, and so when they're providing back injection into the grid, they're providing the same service back. So that's the interpretation that Pennsylvania has done. Alternatively, there is another way you can look at net energy metering, that it is a non-firm provision of energy. It's intermittent. It's dependent upon the customer's demand within its premise, and the availability of solar or renewables, such that you can't. There is no ability to dispatch or to provide any backup or expected capacity or reserve adequacy from these resources. So there's as I said, that's a kind of spectrum on where you are in terms of how do you want to look at energy and metering. And it really, as I indicated, depends on what are the standard statutes within a state. There's regulatory rules on perhaps take precedence on what would be the determination. But I think that it's an important decision, an important consideration that each regulator will need to take a look at, because net energy metering provides full retail value for someone who's participating, and DER aggregation into the wholesale market we're receiving wholesale. So clearly, net energy metering is going to be more advantageous in most cases. I know there are some different versions out there, for example, in California, but bottom line, I think it's state specific, and I think the examination of what are the real services being provided need to be considered.
And let me just add on a little bit more, Zach. Unfortunately, in our industry, we say things like net energy metering, and it doesn't mean the same thing in every state, right? And so ultimately, the structure here is about the value and compensation. And let's what if just for a second, as to make this illustrative, but perhaps you could have a net energy metering standard for a state, and that net energy metering standard paid on the basis of your retail energy value. So if anything is coming back, it's coming back into the meter and being fundamentally zeroed out on a real energy basis, and you're getting the full value of a fully vetted and validated regulated tariff that does have all the components of capacity, energy, ancillary services, and all the structure for the full value. There are examples where people have isolated portions of just capacity, just energy on the bill, where energy is a straight pass through, and the rest of the component charges for metering or infrastructure on the distribution side are separate from that. So if you are just netting energy in your net metering tariff, that is not a full value concept that has the possibility that if somebody has a battery or a dispatchable resource, that it could potentially participate in a capacity program and be dispatchable, even though it's on that quote net energy metering tariff, because the state or the utility has proactively separated those components. And so it's difficult to make a broad statement here because everybody has set these things up slightly differently. But ultimately, the primary guidance would be to clearly understand what value streams are being recognized in a net energy metering tariff and whether that is a full requirements concept and all of the billing components for infrastructure, meter service, riders, everything else is all bundled up in one overall energy rate, or if things are currently being separated, energy is separated and other services or line items specifically, so that you can move in a different direction with that thought process. So each jurisdiction, as David said, will need to look at this carefully and make sure they clearly understand what their existing programs and tariffs represent in terms of value creation and value payment for what they've put forward, and then make a determination about if they need a new and different tariff to be able to facilitate a consumer's ability to participate outside of net metering. They're going to have to move off of that structure and into a new one, or if there is a change in what they're doing on their net metering side.
Let me
Does
just
that help?
add, yeah, let me just add just a couple of things. One, I would recommend go take a look at our tracker report on the subject, where there are the citations to the Massachusetts and Pennsylvania are there. You can go look at some of their thought process on that. And then the second item, I neglected to mention that FERC has opined on this issue also, and particularly in the PJM compliance, has indicated that there's a possible separation that a net energy metered resource could provide ancillary services. So it's opened that door there in at least the PJM. So the idea being that, as Chris was mentioning, lack of dispatchability, lack of ability to, so if you can provide those things, then perhaps you can provide the frequency response or provide other forms of ancillary services.
Did that make it worse or better, Zach?
No, sorry, I was just trying to get back to unmute. That was really clarifying. Thank you. I appreciate spending the time there. Thanks.
Any additional questions? Well, great. Thank you all so much for participating today. Thanks for the questions, and please, FERC2222.org. All of this information, again, the citations for these different things to be able to dig deeper. And Tom, thanks again for the heads up on the other proceedings that are coming. And we'll get those and make sure that we keep those added to the tracker. And with that, again, thank you all. Join in the chat sessions on the website if you're involved on the regulatory side of this, and we look forward to interacting again on our next webinar.